Child abuse charges in Rogers County are generally felony crimes under Oklahoma law. These cases are treated very seriously because they involve allegations that a child was harmed, threatened with harm, neglected, sexually abused, exploited, or placed at risk by a person responsible for the child's health, safety, or welfare. Child abuse is generally a felony in Oklahoma under Oklahoma law. A person who willfully or maliciously engages in child abuse may be charged with a felony. The punishment can include imprisonment in the custody of the Oklahoma Department of Corrections, imprisonment in the county jail, a fine, or both. This means child abuse is not normally treated like a low-level misdemeanor assault. If the state files a child abuse charge in Rogers County, the defendant should assume it is a serious felony case unless the charging document shows a different or lesser offense. What does Oklahoma law mean by child abuse? Oklahoma law defines child abuse broadly. It can include willfully or maliciously harming a child, threatening harm to a child, failing to protect a child from harm or threatened harm, or willfully or maliciously injuring, torturing, or maiming a child under 18 years of age. This definition can cover many different allegations. Some cases involve claims of physical injury. Others involve allegations of excessive discipline, unsafe living conditions, failure to protect, exposure to dangerous people, or conduct that the state believes placed the child's health or safety at risk. Child neglect can also be a felony. Child neglect is related to child abuse but is not always based on the same facts. Neglect allegations may involve claims that a person responsible for a child failed to provide necessary care, supervision, shelter, medical care, protection, or other basic needs. In Oklahoma, child neglect may also be a felony when the statutory elements are met. These cases often involve DHS records, school records, medical records, home conditions, witness statements, law enforcement reports, and prior concerns about the child's care. Enabling child abuse or neglect a person does not always have to be the person who directly caused the injury to face a serious charge. Oklahoma law also recognizes enabling child abuse, enabling child neglect, enabling child sexual abuse, and enabling child sexual exploitation. These charges may arise when the state claims a parent, guardian, caretaker, or other responsible person knew or should have known a child was at risk and failed to take reasonable action to protect the child. These cases can be fact-heavy because they often depend on what the accused knew, when they knew it, what they could have done, and whether the state can prove willful or malicious conduct. Child abuse cases can involve DHS and criminal court. A child abuse investigation may involve both DHS and law enforcement. DHS may investigate child safety, placement, and family conditions. Law enforcement and the district attorney may investigate whether a crime occurred. These two systems are related but not identical. A person may have to speak with DHS, police officers, detectives, school officials, medical providers, or child advocacy personnel. Statements made in one investigation may affect the other. Anyone accused of child abuse should be careful about making statements without legal advice. Not every injury is child abuse. An injury alone does not automatically prove criminal child abuse. The state must prove the required elements of the charged offense. A defense may focus on whether the injury was accidental, whether the explanation is medically consistent, whether another person caused the injury, whether the state can prove timing, whether the accused had access to the child, and whether the accusation is based on assumption rather than evidence. Discipline versus abuse. Some cases involve allegations that discipline crossed the line into abuse. Oklahoma law does not make every act of parental discipline a felony. However, discipline may lead to criminal allegations if the state claims the conduct was willful or malicious, caused unlawful harm, involved excessive force, or placed the child at serious risk. These cases require careful review of the child's age, injury, method of discipline, surrounding facts, witness statements, photographs, medical evidence, prior history, and whether the accused acted with criminal intent. Punishment can be severe because child abuse is generally a felony. Punishment may include prison time, county jail time, fines, probation, court costs, counseling, treatment requirements, restrictions on contact with children, and other court-ordered conditions. A conviction can also create long-term consequences for employment, housing, custody rights, firearm rights, and professional licensing. The actual punishment depends on the exact charge, the severity of the injury, the defendant's criminal history, the child's age, whether sexual abuse or exploitation is alleged, whether the case involves neglect or enabling, and the strength of the evidence. Possible defenses to child abuse charges. A child abuse accusation is not the same as a conviction. Possible defenses may include accident, lack of willful or malicious conduct, reasonable discipline, mistaken identity, false allegation, insufficient evidence, lack of causation, medical explanation, unreliable witnesses, constitutional violations, or proof that another person caused the injury. Medical evidence can be especially important. In some cases, expert review may be helped determine whether the injury is consistent with abuse, accident, illness, birth condition, developmental condition, or another explanation. Talk to a Rogers County child abuse defense attorney.